Hi there, this is Jonathan Ginsberg, and today I'd like to describe for you what actually happens at a Social Security disability hearing. I think it's easy for attorneys like me to just assume that people know, and we sometimes forget that you've probably never been through this before. It's really important for you to understand what actually happens so that you're prepared. I like to call it knowing where to stand, because I remember when I first started practicing law, we learned about what happened at various hearings and trials and so forth, but nobody really ever said, this is where you stand, this is what actually happens. And that's actually pretty important, because if you're comfortable about what's going to happen, you can do a better job and you can really focus more on what you're trying to say as opposed to, again, where you're trying to stand. So let's kind of walk through what actually happens at a hearing so that you know where to stand, what to do, what's going to happen. First of all, let me tell you a little bit about the hearing room itself. Social Security hearings are not court hearings, they're not judicial hearings like you might have seen in a regular courtroom where you have a bailiff and a jury box and so forth. These are what they call administrative hearings, and what that means is that there's a judge there, there's no opposing attorney there, and it's very informal. This is not like a court where you have, everybody rises when the judge comes in. The judge is already in there. It's pretty informal. There's no complicated rules of evidence and so forth. So basically, we just go into a small hearing room. When you get in there, you're going to see really two conference tables. One conference table is kind of in a T formation. The judge is at the front, usually in a raised platform a little bit, not always, but usually. And then you'll be sitting directly opposite the judge. I'll be sitting to your left or to your right. And then to the other side of the table, to your left or right, depending on whatever side I'm not on, will be a vocational witness or possibly a medical witness. There'll also be a hearing reporter at the front of the room who operates equipment that takes audio recordings of hearings. They don't videotape them at this point, they just audio record them. So there is somebody operating that equipment. It's a computer, and they operate the recording equipment. I've also noticed that recently there have been situations where judges will have vocational or medical experts appear by telephone. Again, this is much more informal than regular court, where that would never happen. But you have an expert witness appear by speakerphone. So that's generally the parties who are there. So it's going to be you and me, obviously yourself as the claimant, me as the attorney, the judge, the hearing reporter. Most cases will have a vocational witness. Some cases will have a medical expert. And that's pretty much who the parties are. Witnesses are rarely called in Social Security cases. We can call them if we feel like we need to, but usually the judge is going to get what he or she needs from the claimant. I only bring witnesses, and typically if the issue at hand has to do with mental health problems where somebody might not be able to describe what they're going through, because again, part of the problem they may have is difficulty communicating. If that's the case, I may bring a witness, but normally I don't use witnesses unless I feel it's really necessary. These hearings are designed to last about an hour. So there's not a lot of time for extensive witness testimony. Every once in a while you have a case that will drag on for an hour and a half or 2 hours, and that's pretty rare. And my experience has been that if the case is going to last longer than an hour, that's probably going to be a more difficult case, and it's pretty unusual. So that's pretty much how it works. It takes about an hour. It's usually just going to be you and me, and again, the few other witnesses, people there. When you do testify, it's very important that you speak very, very clearly and say yes or no to a yes or no question. Don't nod your head like this, or say mm-hmm, or yeah, whatever. You need to make sure that the judge clearly understands what you're trying to say, because if you say mm-hmm, that's unclear as to what that means. And somebody listening to a tape, an audio tape down the road, won't really know what mm-hmm meant. So you want to make sure you speak up and say yes or no. And in fact, if you do say mm-hmm, the judge will probably stop you and say, I need you to clarify and tell me what that means. If I'm taking testimony from somebody and they nod or say mm-hmm, then I'm going to ask them to stop and clarify what they say. Similarly, you want to make sure you're very clear about your testimony. Try to stay away from things like not very much, not very long. For example, if the judge says, how long can you sit? Not very long. Well, what does that mean? It's not very long. 4 hours, 6 hours, 10 hours? You want to be very, very specific. I can sit for 10 to 15 minutes. I can stand for 10 or 15 minutes. I can lift 5 pounds. Know that a gallon of milk is 8 pounds. A 5-pound bag of sugar obviously is 5 pounds. So try to bring in some common frame of reference so that the judge knows how much you can do of certain of these physical type of tasks. So those are some things I think you should keep in mind when you're preparing for your hearing. Now, as far as the sequence of the hearing itself, it usually begins with the judge welcoming you and then giving a small introductory speech, basically to say that, do you understand the issues in the case? Usually the judge will direct that to me, and he or she will say, Mr. Ginsberg, have you explained the issues to your client? Can I waive the reading of a formal opening statement? Usually I'll say yes. And then the judge may explain to the claimant, to you as the claimant, this is going to be an informal hearing. If you need to be comfortable, you can sit or stand. If you need to stand up, just stay near the microphone, but you don't need to ask permission to do so. If you need to take a break, you can do that as well. Just tell us if that happens. That's the case. So normally the judge's introduction will take about 5 minutes. He'll ask me, do I have any objections to the evidence in the record? And unless there's some reason for me to object, I almost always will say, no, I have no objection to the record. I've always reviewed it, so I'm always going to say, yes, I've reviewed the record. Then the judge will ask me for an opening statement. In most cases, again, not every judge does it, but the judge will ask for an opening statement. I will set out my theory of the case, why I feel you're disabled. I may highlight certain pieces of evidence by exhibit number. If there's anything I need to bring to the judge's attention, for example, if this is a closed period case where we're only asking for benefits from a starting time to an ending time, I'll bring that up. If there's some unusual issue that needs to be addressed, like there was a previous hearing, the judge may not be aware of it, I'll bring that up as well. And basically, that's my opening statement. It will take about 3 or 4 minutes, and I'll just really spell out the issues as clearly as I can. And I find that sometimes a good opening statement will go a long way to help the judge understand the issues and really can shorten the hearing, and sometimes will result in a quick, favorable decision. It also shows the judge, I'm sending the message to the judge, I'm prepared, I reviewed the record, and I know my case. The judge may then ask a few opening questions to you. The questions might be, what type of place do you live in? Are there stairs? Who do you live with? Do you drive a car? That sort of thing. Just kind of basic background information. Sometimes the judge will go into past work, but usually it'll be pretty brief, especially judges who know me or know your attorney. They'll usually turn it over to us pretty quickly. Once I'm given authorization to start asking questions, I'll go through my series of questions. I usually start by asking about past work and have you describe what you did. Of course, we've gone over this ahead of time. We'll talk about past work, then we may talk about the reason why you left your last job. We may go into the specific issues of why you're continued disabled, and so forth. And I've got a very sequence of questions I ask, and it really kind of depends on the case. But my direct examination may last 15 or 20 minutes, and I really try to bring out those pieces of evidence I think that are most important, and I try to elicit testimony from you about what you can and cannot do, because I realize that most of these hearings are going to be based on your functional capacity for work. So I'm really going to focus very hard on specific activities that you can or cannot do. So for example, if the issue has to do with a lifting capacity, I'm going to really try to pin you down as to how much you can lift. If it's a pain case, I'm going to really try to get a sense of when you experience pain, for how long, at what level. And again, I always prepare you ahead of time as to the best ways to frame your answers so that you do so in a way that really is most compelling and that gives us good evidence, the right kind of evidence that we need. After my direct examination, the judge will ask a few questions in cross-examination usually, and sometimes the judge doesn't have any extra questions. But assuming the judge does, then we'll have a cross-examination by the judge, which usually will be following up my questions or honing in on something maybe I didn't talk about or didn't talk about enough to the judge's liking. That's usually pretty brief. Then the judge will turn to the expert witnesses. If there's a medical expert there, and that's kind of unusual, we don't normally see them. I'd say maybe 10% of the cases. The judge will ask the medical expert to summarize the medical evidence of the case. And usually if the medical expert is good, that's going to be pretty much accepted. Now, I do have an opportunity to cross-examine the medical expert, but usually if the medical expert has testimony that's really in your favor, of course I'm not going to cross-examine him. If it's really against you, I can try to pick away at it, but realize the judge is probably going to go with what the medical expert has to say. But again, medical experts are pretty rare, maybe about 10% of the cases, at least in my experience. Next, the judge will turn to the vocational witness and ask the VE, vocational expert, some questions. Usually it starts by asking, the judge will ask the VE to describe your past work and characterize it based on something called the Dictionary of Occupational Titles, which is a Department of Labor publication that spells out the physical and mental requirements for various jobs. And the VE will testify about that. He may testify about any transferable skills. Then the judge will pose a series of hypothetical questions to the vocational witness. And even though they're hypothetical, obviously the judge is really talking about you. And the purpose of this is for the judge really to translate your medical issues into specific work limitations. So the judge will say something like, assume we have a hypothetical individual with the same age, education, work experience as the claimant. Assume further I find that this hypothetical individual is limited to light exertional work. And that's a term of art, there's a definition with that, with the following additions and additional limitations. This individual would not be able to perform work on ladders, ropes, or scaffolds. This individual would be limited to lifting over shoulder level with the right upper extremity. This individual could push up to 25 or 30 pounds, but could not pull more than 10 pounds. And again, whatever the limitations the judge may have, obviously the more the better. And based on the hypothetical, the vocational witness will testify, yes or no, this person could return to the claimant's past work, yes or no, there are other jobs. And obviously we're trying to get the VE to testify that there are no other jobs. And sometimes the judge will start with a question that has got very general, moderate limitations, of which there'll be plenty of jobs, and kind of moves down the road to the more significant limitations. Sometimes the judge will stop and have me ask questions. And of course, the questions I'm going to ask are always going to elicit the response of there are no jobs this person can do. And if you remember when I told you that it's really important to testify very specifically, I find that a lot of times judges take your testimony and plug them right into that hypothetical question. So, for example, if the question is asked by me or by the judge, how much can you lift, and you say 15 pounds, that 15 pounds is going to find its way into the hypothetical question. So it's really important to prepare ahead of time to think about those things, because if you cannot lift a gallon of milk, which is 8 pounds, you don't want to be testifying you can lift 15 pounds. So again, that's why it's really important to prepare and to come to meet with me prior to the hearing so we can practice some of these questions. And of course, I always try to meet with my clients in my office, days or weeks ahead of the hearing so we can practice those questions. So after the hypothetical questions from the vocational witness, the judge may ask for a closing, or the judge may say, is there anything else we need to cover? Usually there's not, at which point the hearing will be over and you'll be able to get up and leave. Now, the judge will not announce his or her decision right then. It'll be issued in anywhere between 4 and 8 weeks thereafter. And of course, we don't know what's going to be. Sometimes I can tell, sometimes I can't. Sometimes I think I'm going to get a favorable and the judge comes back against me, and sometimes vice versa. I think no way the judge will ever approve this case, and sure enough, it gets approved. So we never really know, although I usually have a pretty decent sense because I know my cases and I usually have a pretty good feel of whether we were able to convince the judge. So that is pretty much what happens at a hearing. It's pretty straightforward. They last 45 minutes to an hour. It's a fairly formal sequence, and as long as you prepare ahead of time, think about what you want to testify about, there's really nothing to worry about. It's very informal, very friendly, and I'm sure that if you prepare properly, you'll do just fine. So this is Jonathan Ginsberg, and I hope this has been helpful, and we'll talk to you soon.